I formally welcome you, my dear brother, with a very, very warm good morning to you and your classmates who are likely to join in a short while. On the last occasion, we were deliberating certain important initial dimensions of the institution of Ombudsman. In this connection, my dear friends, I have submitted my preliminary understanding about the institution of Ombudsman. And when I left on the last occasion, day before yesterday, we were deliberating origin and evolution of the institution of Ombudsman. Dear friends, some of the important genesis I have already submitted, I have already covered. And in the same continuation, in the same direction, if you take an example, how in different geopolitical entities the institution of Ombudsman evolved. For example, Persian Empire. In Persian Empire, King Cyrus charged the O'Hallow-D-Ray, a gentleman and official with the duty to supervise the activity of all his officials. On another occasion, my dear friends, during the 15th century, the Council of Ten in Venice, in Italy, had the mandate to control the bureaucratic excesses committed in the city. And during his exile, my dear friends, in Turkey, the King of Sweden, Charles XII, observed the working of Divane Mazalim. So Divane Mazalim was a very, very important institution. On restoration, the king ordered to establish a similar institution in Sweden. So you can very well understand the King of Sweden, when he was exiled to Turkey, he also learned the governance architecture of that point of a time, how institutions like Divane Mazalim was established, and a similar institution upon his restoration, upon his going back to his country of origin, that is Sweden, Charles XII has also established a similar institution in Sweden. In Sweden, the office was institutionalized, my dear friends, in 1809 with the title of Justitio Ombudsman. And King Charles XII of Sweden is generally credited as the first ruler to establish an ombudsman office to make government administration more accountable, particularly in the context of Sweden. Ombudsman offices, my dear friends, are established to enforce accountability in government and to protect citizens from act of maladministration and misfeasance. The concept of ombudsman did not spread until the 20th century, my dear friends, when it was adopted. It was adopted by many other Scandinavian nation states, particularly Finland has adopted it in 1919. Denmark adopted it in 1955 and Norway in 1962. The popularity of the institution of ombudsman increased in the 60s when various Commonwealth and other countries established ombudsman offices, including New Zealand in 1962, United Kingdom in 1967, and most Canadian provinces, they have also started, my dear friends, because there are as many as 7 provinces in Canada. So they have also started, my dear friends, adopting this institution. And they started in the year, if I'm correct in my recalling, it was the year 1967. Then in Tanzania in 1968, in Israel in 1971, in Australia again in 1971, and even at the in the context of Australia at the federal level, this institution was adopted at the and subsequently at the state level as well. France has also adopted this institution in 1973. Portugal has also adopted it in 1975, and Austria in 1977. Then in the subsequent years, even Spain also adopted the institution of ombudsman in 1981. And in the same year, my dear friends, the state of Netherlands has also adopted this institution, and that was the year 1981. On the other side of the globe, American interest in the concept of ombudsman, they generally refer it as ombuds. They are not using the word man in the institution, or with this particular word, as I was talking of, that this should be made gender neutral. So the institution of ombuds gained popularity in the United States of America in the middle of the 1950s, when American scholars, lawyers, and politicians began exploring its applications in the United, or in the context of the United Nations organizations. And by the late, what we call 60s, ombudsman offices in the United States of America were constituted to investigate and respond to public's complaints against the behavior of the governmental agencies and governmental instrumentalities and officials. My dear friends, the American concept of the institution of ombudsman, or the institution of ombudsmanship, has expanded since then, with prisons, higher learning stations and centers, universities, school systems, hospitals, cities, and corporations establishing their own ombudsman offices. Likewise, my dear friends, there has been a proliferation of the client ombudsman, including thousands of patient representatives in hospitals, over 35 newspapers, ombudsman serving readers, public utility and public service ombudsman, and ombudsman for public agencies were also contemplated and emplaced. We are also having, in the context of South Asia, we are also having these kinds of institutions. Suppose in India, institution of ombudsman, internal ombudsman have been established by many of the daily newspapers like Times of India and other important what we call news dailies. So while ombudsman institution, my dear friends, or as a whole, as a collective, arrived relatively late in the context of Asia. Scholars in our part of the world have noted the presence of ombudsman like officials or institutions in the ancient civilizations of Asia. Long ago, muhtasibs in Muslim countries were entrusted with the responsibility to ensure, or ensuring, that officials acted correctly, morally, and with a full what we call strength or full moral convictions of probity. They toured cities, towns, and marketplaces on a daily basis and had the authority to reverse an official order if they the same order was considered by them as morally incorrect or unjustified or unjust. In 15th century Korea, my dear friends, during the reign of the king Taejong, the Yi dynasty had the what we call drum of justice. And in the Korean language, my dear friends, this drum of justice was known as sharmango. Outside the palace, anyone who wished to report an injustice could do so by hitting the drum. So it was basically the drum of justice. In the form of this institution, in the manifestation of this kind of an institution of ombudsman. One of the king's secretaries would then come out and attend to the citizens' grievances. As I have already told you on previous occasion, my dear friends, in the context of ancient China, had an institution known as the censorate, and censorate whose mandate was to monitor the government, to detect any maladministration and threaten the rights of the people. That was the basic and the most fundamental purpose of this institution. So in a way, my dear friends, we find that majority of the nation states in their evolutionary process, in their journey to establish an accountable, responsible, transparent, trustworthy governance architecture, they have adopted this idea of vigilance called institution of ombudsman. So if we have to assess the importance of this institution, the institution of ombudsman, then it becomes very much prolific, it becomes very much important, my dear friends. If I am allowed to quote one of the most important authority on this particular aspect, I'm talking of the Professor Giles. Professor Giles Peck explained the concept of value added ombudsmanry, which elevates the ombudsman from a mere complaints department to an architect of the better governance, good governance, transparent governance, or trustworthy governance. At this stage, to underscore the importance, relevance of the institution of ombudsman as an arbiter, as an administrative trustworthy leader, as a defender of transparency, as an institutionalizing force, as a accountability and the rule of law institutionalization mechanism, duties of the institution of ombudsman become very, very important. My dear friends, the duties of the ombudsman should go beyond the basic mandate of providing redress. According to Peck, Professor Giles Peck, the trigger may still be personal damage and complaints, but the answer can no longer only be personal reparation, it must also entail eliciting what might be a plausible and reasonable appreciation of the nature of the dysfunction, and in some promising, in the some reckoning organizational redesign and architectural repairs to the governance wherewithal and apparatus. So therefore, it is not only the duty of the institution of ombudsman, my dear friends, but at the same time, a reasonable, plausible, and pragmatic critical appreciation of the administrative actions must also be ensured as a part of the duty, as a part of his duty while acting in the capacity of ombudsman. And it is also important, my dear friends, for the ombudsman to have the capacity to detect governance flaws, misgivings, missives, disconnects at the origin of these what we call mishaps, and to help launch the process that will ensure that the governance apparatus, governance wherewithal is appropriately and sufficiently repaired. In other words, we can put it like this: the ombudsman is seen as a crucial mechanism for enhancing governmental efficacy, effectiveness, and primacy. So, therefore, it should, under all circumstances, be institutionalized, because there are benefits of institutionalization. Suppose, in the context of Afghanistan, since Afghan students are listening, so it becomes imperative on my part to cite and to educate you intellectually, as a student, as a researcher, as a civil society member, Afghan civil society stakeholders. It is important, my dear friend, that we must what we call question the transparency aspects of the governance architecture that has been presented to the people of Afghanistan as a Islamic Emirate of Afghanistan. So we have to institutionalize, because institutionalization of the governance architecture, institutionalization of the various agencies which have been contemplated under this particular mechanism, they ensure accountability, they ensure responsibility, they also ensure probity, integrity as officials in different capacities at the disposal or are appointed at the service of the ordinary citizens of Afghanistan. So that is very, very important, because institutionalization ensures continuity, integrity, and stability: administrative stability, judicial stability, political stability, executive stability. So therefore, the importance of the institution of ombudsman has to be further strengthened by institutionalizing various departments and their responsible behavior. Therefore, my dear friends, in other understandings, I can say that the institution of ombudsman, my dear friends, is known as a part of democracy, as a part of democratic development, as a part of governance, as a part of the public administration in the contemporary circumstances, not only in Afghanistan, this entire what we call South Asia and beyond South Asia. Therefore, ombudsman institution is of common, my dear friends, when we are talking, it must be of common man that should be at the receiving end in the context of what we call exercise of the power, discretion of the government and the bureaucracy, who operationalize many of the important aspects, and it is the legitimate expectations, my dear friends, of the ordinary citizens, and they have reposed all their high expectations from their governments, the emerging welfare philosophy, the inbuilt character of the government placing heavy burden on the governments, and it must also, the government is expected to take care of its citizenry. It is also what we call expected that the government is going to provide innumerable points of controls between the people and the government, leading to the numerous kinds of grievances which people face in their day-to-day life, and that should be the what we call of understanding of the institution of ombudsman. Because when we are talking of ombudsman, there are certain specific situations where we immensely feel that the institution of what we call of ombudsman must come for our rescue. Situations of injustice, failure to carry out legislative intent, unreasonable delay, administrative what we call misgivings and errors, abuse of discretion, lack of courtesy, clerical what we call errors, oppression, oversight, negligence, inadequate investigation, unfair policies, partiality, failure to communicate, ill behavior, rudeness, maladministration, unfairness, unreasonableness, arbitrariness, arrogance, inefficiency, violations of law. Not only the violations of law, the transgressions of regulations, violations of well-established conventions and norms, abuse of authority, discrimination, deliberate and inadvertent what we call mistakes, carelessness, administrative carelessness, disagreement with the discretionary decisions, improper motivation, irrelevant considerations, my dear friends, inadequate or obscure explanation, and all other acts that are frequently inflicted upon the governed by those who govern, intentionally or unintentionally, deliberately or inadvertently. These are the some specific situations. There are many other important situations. I am not saying that whatever the situations I have described before your considerations, these are the only what we call situations. You may also contemplate other important situations like crimes against what we call women, crimes of what we call collective punishment, crimes of against humanity. Many other important dimensions are there even on daily basis, like what we call social crimes, ethnic what we call crimes, crimes what we call on the basis of political opinion, crimes against people only on the ground of their social origins. So there are many other important dimensions. And my dear friends, it is not a mere stringing what we call together of words, but product of day-to-day what we call real life experiences in the field of the government citizenship or government citizen relationship. My dear friend, in discriminatory justifying the need of the desirability of having an ombudsman in a situation of discriminatory or discrimination, this reminds me of a very very important what we call administrative jurist or jurist on on administrative law, Lord Shaw. Lord Shaw rightly what he called wrote in the preface to the what report, the man of substance can deal with these kinds of situations. He is near to the establishment, he enjoys the status or possesses the influence which will ensure him the ear of those in authority. He can afford to pursue such legal remedies as may be available, but too often the little man, the ordinary humble citizen, is incapable of asserting himself. And it is the problems of the ordinary citizens in a geopolitical entity that he is always away from republic because he is a part of larger public. So that kind of understanding is always there. Therefore, my dear friends, the institution of ombudsman brings all the elements of good governance in administration, such as transparency, as I have already submitted, objectivity, efficiency, accountability, economy, and human touch in administration. And that is the missing link in entire South Asia and beyond what we call South Asia. Particularly, it is true in the context of global South nation states, because the persons of the institution of ombudsman has therefore a tonic effect, my dear friends, on administration. The way persons of administration, the way the persons of ombudsman changes the entire perception of bureaucracy in dealing with cases brought before them for decision making. No wonder the ombudsman has been described as an administrative doctor or a auditor general of human relations accounts. It is very very important, and that is why on daily basis we have been talking of, let us have a humane face of administrative machinery. Let us have trade and businesses with the face of humanity. Humane idea of what we call of the scientific development. Humane idea or humane face of the application of the artificial intelligence. All these developments we have been what we call talking of, because the human touch creates some kind of a healing effect, some kind of a very very, or as I have already told you, some kind of a tonic touch or the tonic effect that is going to soothe the ruffled feathers of our ordinary citizens or ordinary people whenever they are demanding some kind of justice to the or coming with some kind of idea of justice. Therefore it is important, my dear friends, when we are basically talking of ombudsman, Etymologically speaking, my dear friends, the word, ombudsman is rooted in the word, ombuds. Ombuds means, my dear friends, essentially meaning the representative. It is an indigenous term which is found in Danish, Norwegian, and Swedish languages. Modern variations of this, term includes ombuds, ombudsperson, or ombudswoman. But we were, deliberating it on the last occasion. I, suggested an idea of, gender neutrality. And in the case of, gender neutrality, it is important, to my dear friends, that we should, revisit this particular, terminological expression, and we should find and there has to be some kind of a consensus so far its use is concerned. It should be ombudsperson, and the post of, ombudsperson, my dear friends, must be instituted by other, governments or organizations. Particularly, it is true in the context of what we call of, at regional level. So, in the institution of ombudsman must be established at the SARC level, at the EU level, at the ASEAN level, and other, groupings also, demands, and they should demand the similar what we call, institutionalization. Then only we can understand, because the word ombudsman and its specific meaning have been adopted in various what we call, languages, as I have already, told you, whether it is Spanish, Dutch, Czech, or Arabic. Everywhere we find the expression like this. So, is there any kind of a possibility to have a definition of the institution of ombudsman? How should we try to define this particular, terminology? I mean, this particular, expression, institution of, ombudsman. How to define it? Any attempt on your part? Dear guys and dolls, the committee of the International Bar Association resolved in the year 1974 that the term ombudsman should mean only grievance handling mechanism. And this committee of International Bar Association, my dear friend, has tried to define this institution of ombudsman or ombudsman per se. Yes, the definition, my dear friends, I quote for your understanding. As per this, committee constituted by the International Bar Association in 1974, it has endeavored to define the institution of ombudsman or office of the, institution or office of the ombudsman. It was of the view, I quote, an office provided for by the Constitution or for by actions of the, legislature or parliament, and headed by an independent high-level public official who is responsible to the legislature or parliament, who receives complaints from aggrieved, people or persons against governmental agencies, complaints from other, segment of, society, officials and employees, who acts on his own, motion, and who has the, power to investigate, to recommend corrective, actions, and issue what we call, all kinds of reports. unquote. So this is the, one attempt that has been, made. So you can very well understand, my dear friends, that there have been, important stages in the process of, institutionalization of this particular, office of the ombudsman. So therefore we can say, my dear friends, that this is an office which must, provide this is an office, I mean the institution of ombudsman must be the part of the, founding document. It must be the part of, constitutional understanding and constitutional scheme. It must have its what we call, constitutional authority, and that constitutional authority must be respected by all. It is the fundamental responsibility of the state institutions they must adhere to, including the what we call, judiciary, because this has always been a bone of contention among the various, stakeholders. Should, even in India, it has been contested, should judiciary be the part of what we call of the jurisdiction of the institution of ombudsman. Personally, I feel even the judicial establishment must also be accountable to the institution of ombudsman. And I go to the extent of putting on record, my dear friends, for your consideration, whenever in South Asia constitutions are amended or this kind of institution is contemplated under the various provisions, except what we call, right now we are having two important constitutions, the constitution of Bangladesh and constitution of Pakistan, where certain specific provisions have also given some kind of constitutional treatment, and these provisions have also contemplated the institution of ombudsman. So institution of ombudsman, my dear friends, must be the part of of appointment of certain important constitutional positions or the constitutional authorities, like election commissioner in each and every geopolitical entity of South Asia. Selection or appointment procedure must also include the institution of ombudsman or ombudsman per se, or ombuds person per se, as a part of what we call of appointment process. Promotion and elevation of the judges to the higher judiciary, any kind of a mechanism, whatever the mechanism, existing mechanism, must be reformed, or potential what we call mechanisms which are under consideration in many of the countries in South Asia must include as a member, indispensable what we call member, this particular office, and this is the office of the office of the institution of ombudsman, or ombudsman himself or herself must be the part of this kind of a mechanism. If she is going to be, then she is ombudsperson, or if for all practical reasons, this is my well considered opinion, that only the word ombudsperson should be there instead of ombudsman and ombudswoman, because both the words are utilized and used in the context of the United States of America. So that should be the program and policies. So far the functioning or operationalization of this kind of an institution is concerned. In the later years, my dear friends, particularly in 1983, we come across another important what we call definition, and this is the definition that was provided by Gerald E. Cadell, a constitutional authority. He was of the view that the institution of ombudsman is an independent. I'm not able to reproduce his exact language, but he was of the view that the ombudsman should be an independent, non-partisan officer. If there happens to be an office of ombudsman or a committee of ombudspersons, then the officers or the composition of this kind of a committee, often provided for in the constitution, must also supervise or supervises the administration It must, deal with the specific complaints from the public against administrative injustice, violations of the, rule of law, or any sort of, maladministration. And the committee must have the power to investigate, report upon, and make certain specific recommendations about individual cases and administrative, what we call, procedures, because the process should not be a process of punishment. So many attempts, my dear friends, have been made with regard to the, institution of, or how to define this particular, concept of ombudsman. Therefore, cumulatively speaking, we can say at this stage that an ombudsman is an official usually appointed by the government or by parliament, who is charged with requesting the interest or representing the interest or safeguarding the interest of the general public by investigating and addressing complaints reported by such individuals, such individual citizens, or some, what we call, the groups of individuals or group of people. We can say very authoritatively, my dear friends, although you got every right to disagree with me, an ombudsman is a person who acts as a trusted intermediary between an organization and some internal or external constituency, while representing not only but mostly the broad scope of constituent interests. Therefore, in some jurisdictions, my dear friends, an ombudsman formally referred to as the parliamentary commissioner. Parliamentary Commissioner for Administration, and the Western Australia or Australian state, what we call, ombudsman in the context of what we call of, Australia. And when I'm using the word, parliamentary commissioner, then parliamentary commissioner, this kind of an office is addressed in the United Kingdom. In United Kingdom, my dear friends, an ombudsman is known as parliamentary commissioner. That is the, what we call, current understanding. And we must try to, because I have already referred to you that there is a, UK's Code of, Public Services, which was adopted in 2010. A day before yesterday, I made a reference of this particular, code. So therefore, we can say, my dear friends, in many countries where the ombudsman remit extends beyond dealing with the alleged maladministration to promoting and protecting human rights, the ombudsman is recognized as the national human rights institution as well in many of the, countries. An ombudsman may not be appointed by a legislature, my dear friends, but may instead be appointed or even work for a, corporations such as a utility supplier or a newspaper, as I have already submitted, for an, non-governmental organization, for a, professional regulatory, body, or for local or municipal, what we call, government. In some countries, an inspector general may have duties similar to or overlapping with an ombudsman appointed by the legislation. Making a complaint, my dear friends, to an ombudsman is usually free of charge. So therefore, we have also, and in the similar, what we call, fashion, even many legislations have also been, passed. Even the government of India has also passed the Freedom of Information or the Right to Information legislation, I think in 2005. So it has also, contemplated about the administrative matters, administrative actions. We can also, what we call, report, we can also, ascertain. Because when I happened to be in my previous institution, I was, working in my, in one of the, administrative, capacities in the office of the, proctor over there. So I have also, received, because by virtue of my being an associate, proctor, I was also looking after I mean, the complaints, information, and other important, inquiries, which were, received under the mandate of, right to information legislation passed by the Parliament of India. So one of the complaint, or one of the, information was, sought about my, how many cup of teas I generally take in a day whenever I attend office, particularly the proctor office. So people, ask, because I failed to understand, if I am taking 2 cups of tea during what you call 4 hours or 3 hours time, will it affect adversely, will it or would my taking tea caused some kind of a would cause some kind of a problem to any of the students. So very, I mean, the frivolous complaints are also lost. So we have to determine, my dear friends, either there should be a violation of the individual interest in the form of human rights, in the form of fundamental freedoms, in the form of civil liberties, or there should be a violation of some common interest. So at the same time, when we are having, because these kinds of institutions are very vital institutions, and therefore it is the added responsibility of the citizens of any geopolitical entity to exercise a lot of caution, lot of what we call of preparation before lodging or contemplating any kind of complaints. Therefore, my dear friends, some scholars have tried to trace the origin of these kinds of institutions in ancient medieval periods, etc. But as a watchdog of public administration in modern age, it definitely traces its origins to the Swedish Constitution of 1809. It was with the establishment of the office of the Ombudsman in Denmark that the real spread and uniqueness of the Ombudsman system started taking shape. It was primarily the Danish model, my dear friends, that was distinctive from the Swedish one, at least on the on three important what we call counts. Number one, whereas the British, or I mean the Swedish what we call ombudsman was a prosecutor of erring civil servants, the Danish one was an investigator of the maladministration. Point number two, or secondly, the Danish Ombudsman report was in the nature of recommendations, whereas the Swedish one formed the basis of the legal action against what we call, recalcitrant, officials, including courts. And point number three, my dear friends, Danish model, apart from the redressal of individual, grievances, provided guidance for an administrative, what we call, improvement, whereas the Swedish model was based on the punishment of the individual concerned. So these were the some important what we call developments. Another important what we call jurist is also there, and that is, my dear friends, Jan Erik. I think it should be, yes, it is Jan Erik who substantially transformed the role of the ombudsman from a disciplinary what we call body to an investigating what we call or investigation or institution what we call exercising its influence. Norwegian ombudsman that was established in the year 1962. It was basically more or less based on the Danish model of what we call the institution of ombudsman. Until now, the ombudsman was confined to the Scandinavian what we call soil. On the other side of the globe, in 1962, if I give you an example from New Zealand, my dear friends, that is a Commonwealth country, and it has also adopted the institution of ombudsman, and it is known as the Parliamentary Commissioner for Administration in New Zealand. And out of the two terminologies, my dear friends, the Parliamentary Commissioner and ombudsman, the public more frequently used and recognized the office as ombudsman, because the word ombudsman is very, very prevalent and very, very famous so far the global north jurisdictions are concerned. In further, my dear friends, in furtherance of my submissions, in 1962, New Zealand model of ombudsman influenced the Australian idea of ombudsman. New Zealand model further influenced the Indian understanding of this institution of ombudsman, because India, for the first time, my dear friends, experienced, I think in 1971, Government of India for the first time established this New Zealand model of institution of ombudsman at the provincial, what he call, level. And Pakistan has also tried its hand on this institution, I think on the same, what he call, uh, in and around what he call, this year, that is, 1971. So Pakistan has also tried with the idea of, ombudsman system. So Ombudsman office in the UK, my dear friends, so officially, as I have already told you, as the Parliamentary Commissioner for Administration, and that was also established in 1967, added some unique features to the development of ombudsmanship. Unlike the predecessors, UK ombudsman could not be approached by the complainant directly, but through the what we call, members of parliament, or via the members of parliament. England also provided for a standing committee of the House of Commons on ombudsman, and thereby emphasizing that the ombudsman was really an extended arm of the legislature, though practically independent in its investigation, recommendation, or whatever may be the mandate of this body. My dear friends, Britain made a major departure from Scandinavian countries in the ombudsman system by applying certain important unique features and by appointing a person from the non-governmental, what we call, circles to the post of what we call of ombudsman. And it further, asks other types of what we call of, ombudsman for health services in 1972 and local administration in 1975, and so on and so forth. At the same time, my dear friends, Canada, another important Commonwealth nation state, started experimenting with the institution of what we call of ombudsman as a grievance redressal mechanism, as a grievance redressal body dealing with exclusively maladministration at the provincial level. The French ombudsman is another important what we call, and they have, came out with the French, terminology to define or to designate this kind of an official called ombudsman in other what we call, jurisdictions. In the context of, France addressed the institution of ombudsman or ombudsman as a mediator. That is, if we translate it into English, it becomes a medicator. So it has also, added certain important different, flavor to the system or to the institution of ombudsman in the year 73. So these developments constitute a very, very important what we call, trajectory. So far, the transparency is, concerned. If you take an example from United States of America, what exactly has happened in United States of America? A lot of interest was created in the institution of ombudsman, particularly in the late 60s. Two departments in particular are worth noticing in this particular context. So far, prevalence and adoption of the institution of ombudsman in United States of America is concerned. The creation of the executive ombudsman, as they were set up by the state governors under the constitutional system of the United States of America, governed by the principle of separation of powers. And number two, in the US, my dear friends, the term ombudsman began to be loosely applied in any grievance handling mechanism, whether in public or what we call private concern. So that was the most important development which we find in the context of United States of America. Therefore, if we have to what we call understand the basic and the most fundamental features of the institution of ombudsman, the salient features of the institution of ombudsman, then we can say that the ombudsman, my dear friends, is an independent of government. It is responsible for making sure that the administrative practices and services of public bodies are fair, reasonable, and appropriate and equitable. And ombudsman or should be, considered and regarded as an officer of the provincial, what we call, you know, you know, provincial legislature, as well as an official coming from the what we call the national parliament with integrity, probity, and sanctity. An ombudsman must be able, my dear friends, to conduct confidential investigations that are not threatening, or and it must what we call, protects and ensure the what we call, safety and security of the complainants. As we have been what we call, contemplating an idea that even the whistleblowers must be protected. Security and safety of the whistleblowers in each and every what we call, context must also be what we call, protected. Another important, programs in many geopolitical entities for the sake of what we call of a one fundamental right, and that fundamental right, my dear friends, constitute highly important one in the entire what we call, schematizations of the human rights challenges at international level. And one of the most important challenge, how to ensure a fair trial guarantee. So it has become in many geopolitical entities, the protection of witness program or witness, protection programs are generally monitored, fostered, and promoted by the judicial establishments, where the security of the witnesses before the, court of law, they are generally, protected. So it is the responsibility that the complainants, witnesses must also be, protected against any kind of a, retribution, against any kind of a, reprisal, against any kind of a what we call, vengeance or vendetta. So their, safety and security must be the part of what we call of this institution of ombudsman, and it required to file an annual report with the legislative what we call, branch of the state, or the highest, legislative body, whether it is the National Assembly, whether it is the, Parliament or Sansad, Majlis, Knesset, whatever may be the diet, whatever may be the nomenclature of this, legislative body, it must what we call, ponder over whatever the recommendations, and as a part of what we call of the annual report, which is submitted by a person called ombudsman, because then only we can ensure independent, impartial, transparent what we call, functioning. And this institution, my dear friends, institution of ombudsman, under all circumstances, universally be accessible and empowered only to recommend and to publicize whatever the, matters have been placed under its, jurisdiction. Institution of ombudsman is not only an instrument of parliament for supervising administrative what you call action, but also a protector of individual rights. Institution of ombudsman undertakes investigations conducted by it are completely impartial and independent of the administrators. Investigation, my dear friends, can be started by the ombudsman at his own initiatives, so moto, basing his actions of the information received by him. It may be a situation, or investigation is conducted informally, or ombudsman has considerable flexibility, my dear friends, in the form of action which he would take in the given situations, or the matters which are generally reported to this kind of a body. Therefore, any citizen can bring complaints before the institution of ombudsman without what we call counseling of lawyers or lawyers or jurists. In Sweden, for example, even prisoners have also the right of what we call of sending complaints to the ombudsman through respective authority, through proper what we call channels. The citizens can send their complaints to the ombudsman in written. I can give you another important example from Finland. In Finland, my dear friends, these complaints can rise orally by the physical persons in the office of the ombudsman. Another important example is also available from France. In France, my dear friends, The scenario, something, different or somewhat different. A French person with a complaint cannot go directly to the what we call, magistrature. Instead, he or she must, communicate with the member of, parliament, who will decide whether the complaint has sufficient merit, sufficient grounds to be passed on for action by the magistrature. Therefore, the institution of ombudsman, my dear friends, can delegate their powers of inquiry to the deputy, but cannot delegate their power of what we call of decision making, or decision what we call or decision relating to the determination so far the culpability, violations, and other important what we call transgressions of the civil liberties, or deprivations from the lawful benefits of the governmental schemes. Therefore, institution of ombudsman has considerable, my dear friends, discretion as how far he can take, how far he can decide a case against an officials. In most cases, institution of ombudsman simply points out the official's error and suggested to the what we call respective authority, particularly to examine any documents, question any person, and demand and very what we call assistance from the accused officers or persons. Let us take the Danish ombudsman. Danish ombudsman is responsible for investigating any complaint against public officials concerning abuse of power, negligence, or abuse of trust. Danish ombudsman, my dear friends, can respect, can inspect, can determine all state what we call administrative actions, and enter all state what we call establishments. Danish ombudsman has access to all minutes and official documents, minutes of meetings. This is the the jurisdiction of the Danish ombudsman, my dear friends. It is the power of the Danish ombudsman. Power of inquiry, or power to inquire about the Finnish ombudsman, is similar to the what we call Swedish ombudsman. So there are a lot of what we call of similarities. Scope of work of the ombudsman varies country to country. Suppose for example, Swedish ombudsman has the power to oversee the courts and the civil what we call servants. But we in our part of the world are not very worried about this kind of what we call of situations. Therefore, it is going to be the fundamental responsibility of this institutions, and we must, while taking into consideration what kind of complaints, what kind of societal composition is there, what is the nature of what we call of crimes, our maturity, our pledges with that of democracy and transparency in our institutional framework, everything must be taken into consideration. Then only we can decide something about what we call institution of ombudsman. Therefore, people can get the opportunity of having justice cheaply through ombudsman. It is a very, very what we call comfortable office, where the ordinary citizens, without any kind of a what we call administrative hassles, can approach. This can be possible for the procedure of ombudsman office. Mostly the function of ombudsman is conducted through postal what we call services, as we have been what we call witnessing in cases of what we call of the consumer protection laws in South Asia. And we can say, my dear friends, because there is no finality to this kind of a deliberation, but I am of the view, my dear friends, that the institution of ombudsman is an outsider within the what we call, or within the entire state structure or administration, because he is a man of legislation. He is a man of the ordinary people and their will. He presents his annual functional and financial reports to the what we call to the legislature. So therefore, it is an extension. Now, the larger question that remains to be answered at this stage is, my dear friends, we have deliberated the entire canvas of the institution of ombudsman at a global level. But what about at the South Asian level? how institution of ombudsman has been functioning in South Asia. Let me take up the first country, and I should what you call geographically I should begin, and I should begin from Afghanistan. So my dear friends, I would like to know from you, in the current scenario, under the Islamic Emirate of Afghanistan regime, do you have this kind of an institution? If this institution is not there, what is the alternative which is available to the people of Afghanistan? So anybody from Afghanistan? Yes, Mr. Noori.
Yes, sir.
Yes. Do you have the institution of Afghanistan? I mean, do you have the institution of ombudsman in Afghanistan?
No, sir. Actually, physically, we don't have nothing and such an institution, but they work uh, according to the last institutions or the last works of the Republic government, and they do not accept that, but in workspace, in the place of work, they just use that institutions, but unfortunately to now they don't have such kind of institution or other things, sir.
In cases of complaints, how do you approach? How do you approach administrative machinery? What is the mechanism which is available to the people of Afghanistan? If
Sir, I
complaints
think
laws, if you are having some kind of a complaint, I mean, there are rivalries, there are ethnic clashes, there are racial what you call contentions, there are complaints on the basis of tribal affiliations, or whether this jurisdiction is available to Loya Jirga or other jirgas at the local level. So what is the mechanism to resolve?
yes, sir. As you mentioned that there is a very good thing that we call it Oloya Jirga, a council of leaders of people that they come together and they just make a decision for uh, big issues in the government. But as we have that in last 1 year, we have just one Oloya Jirga council of leaders, scholars, religious scholars, but they take decision, but that decisions were not just shared with people. That was all hidden from people. So,
Okay.
sir, yeah.
Yeah. Any other observation? Well, since we do not have an institutionalized framework in the context of Afghanistan, and constitution of potential constitution of Afghanistan remains in making, therefore I should not deliberate on the informalities, because there are no constitutional formalities right now, but informal mechanisms are there at every level, at the local level, at the village level, at the provincial level, at some chieftains, level, there are informal systems to attend the grievances of the ordinary citizens of Afghanistan. And you can correct me. So therefore, at a subsequent stage, let constitution be there, let us institutionalize, and Islamic orientation has been what you call attributed to the complaint resolution mechanism in Afghanistan. And on the basis of Islamic fiqh and Islamic dictate, majority of the issues and complaints are being addressed. So therefore, let us begin with Pakistan. In the context of Pakistan, my dear friends, there are as many as 7 ombudsman institutions in Pakistan. And my friends from Pakistan and their vicinity can correct me. 3 provincial and 4 federal, what you call, institutions or ombudsman we generally find in Pakistan. The federal ones are the federal ombudsman, which are generally in Urdu known as Waqafi Muhtasib or federal ombudsman. The federal tax ombudsman is there, the banking Muhtasabi ombudsman is there, or Muhtasabi is there, and the federal insurance ombudsman office is also there. And the last 3 of these, which I have mentioned, Waqafi Muhtasib, federal tax ombudsman, banking Muhtasib, these 3 institutions have been functioning with a single consolidated combined institutional mandate. Provincial ombudsman, on the other hand, my dear friends, exist in the provinces in the context of Pakistan, the province of Balochistan, the province of Punjab, and province of Sindh. My dear friends, in the year 2010, in this particular year, the Khyber Pakhtunkhwa Provincial Assembly has also passed a legislation, and they also what we call contemplated this institution, which provides for the establishment of the office of the institution of ombudsman. In the context of Pakistan, the institution has been empowered to investigate complaints in the context of a public administration and to determine what we call the dereliction, if any, that has been there on the part of administration. So far, the origin of the institution of ombudsman in Pakistan is concerned, as per the Pakistani scholarship, my dear friends, they claim and they trace the origin and establishment of the institution of ombudsman to the Holy Quran. In the Quran itself, the term administration is not used, but in many of its holy verses, the fundamental principles of political and administrative system are expounded. And justice happens to be one of the basic principles of Islamic ideology. Before the times of Prophet Muhammad, peace be upon him, there was no administration in the proper sense of the word. It was the Prophet Muhammad, peace be upon him, who first introduced administrative authorities. He appointed governors of the provinces, judges, and tax collectors. They were all accountable to the Prophet Muhammad, peace be upon him. And there was no report of complaints about these institutions during his lifetime. as essential principles of government, my dear friends, and administration, the Prophet Muhammad, peace be upon him, bequeathed trust, justice, and effectiveness, as well as the combination of authority with the highest amount of magnitude responsibility. It was during the regime of the Umar the Great, the second Caliph of Islam, and this was under his leadership. I mean, the Khulafai Rashidin, the four righteous caliphs empire was also established. So during this particular period, the second Caliph of Islam who created the institution of Mu'tasim, and he enjoyed complete independence and functioned within the framework of an institution called Hisba. And we generally, use this kind of Hisba is an Arabic term which has been, accepted in Urdu language and Hindi language as, which is popularly known as Hisab Kitab. We generally, use this kind of expression. So this is the, origin of this kind of this, expression. So its role was to ensure the observance of the religious principles in daily life. For example, in Egypt, this institution existed up to the middle of the 19th century. So you can very well understand how this entire what we call framework has been designed. So in the context of Pakistan, my dear friends, an interesting fact is that in this context, the institution of Hisba and its functions was also adopted by the Crusaders in Jerusalem. If you take what we call the history of Crusades, it has also been what we call taught in Pakistan. They even use Arab what we call word Muhtasib, I mean, along with some other important what we call Christian expressions, although they change it into what we call Muhtasib, because they have Englishized the terminology. Suppose, take the example I can give you. When in the wake of the Bolshevik Revolution, my dear friends, in 1917, many of the expressions have been Russianized. The name of the people were also Russianized. So therefore, it is a exercise. Suppose, take the example, another important what we call a jurist, philosopher, thinker, Ibn Sina. Britishers has anglicized this spelling, and it is known as in the British history as Avicenna. So same happened with this institution of Muhtasib. It was what we call Mathiseps. It has been what we call addressed like this, though in Arabic it is known as Muhtasib. So institution of Muhtasib or Muhtasib is basically the institution of what we call of Ombudsman, and it has been created in Pakistan under Article 62 of the Constitution of Islamic Republic of Pakistan. So its functions was to be a guardian, and above all, in the marketplace, he was the market supervisor as well as the settler of disputes. In Pakistan, establishment of the institution of Ombudsman was advocated on several occasions. If you take into account, my dear friends, Article 276 for the first time provided for the appointment of a federal ombudsman as well as provincial ombudsman. And we have to study Article 62 as well in tandem with this article, that is 276. So if you take subsequently, my dear friends, the Constitution of 1973 included the federal what we call ombudsman as a item number 13 of the federal legislative list in the 4th schedule of the Constitution of Pakistan. The institution of ombudsman was, however, actually brought into being through the establishment of the office of the Muhtasib, Ombudsman Order 1983, And it is generally what he called known as the President's Order number 1 of 1983, which is now a part of the Constitution of Islamic Republic by virtue of Article 270A. It started functioning, my dear, in the subsequent years, and that is 19 what he call 84. The institution of ombudsman in Pakistan, as I have already submitted at the federal level, it is known as the Wafaki Mahasib. And English, what we call, in English, it is known as the, federal ombudsman. And it has been headquartered, my dear friends, at Islamabad and regional offices in Lahore, Sukkur, Quetta, Faisalabad, Multan, Dera Ismail Khan, Peshawar, and at many other important, places in, Pakistan. Therefore, the government of Pakistan has enacted an act which is popularly known as, my dear friends, the Protection Against Harassment of Women at Workplace Act of 2010 in 2010. And it was basically the direct what we call reception of the judicial creativity which we have witnessed in the context of India. And that is very, very important. One of the most important decision that was delivered in India by the Honorable Supreme Court of India, and ultimately it was taken. And I am talking of, my dear friends, the judgment which is popularly known as the Visha judgment. Under this particular judgment, you might have studied what has been the mandate of this judgment, and this judgment has been what we call accepted and adopted as a piece of legislation. And the why I am making a reference of this judgment at this stage is because the institution of ombudsman, how to protect women and their what we call personal integrity and their personhood at the workplaces, that power has been provided to the institution of ombudsman in this particular context. And it was this legislation which ultimately created some kind of a safety wall, some kind of a firewall, and that has ultimately protected and saved women from harassment at the hands of their counterparts at the workplaces. So in many provincial what we call in many provinces or many federal what we call units of Pakistan, some legislations have been contemplated on similar lines. This reminds me of the a very first what we call woman, I mean Mrs. Musarrat Hilali. You can correct me, my dear friend from Pakistan, Mr. Bhagwan Das, and Mr. Dilip, you can correct me if I am wrong in my submissions. It was, Mrs. Musarrat Hilali who has been appointed as the first ombudsman for the protection of women against harassment at the, workplaces. So this has been the what we call overall, understandings. If you take other, jurisdictions in South Asia, suppose you can take another important, jurisdiction. I'm not talking of India. You can take Sri Lanka. The government of Sri Lanka has designed several ombudsmen for the redress of grievances and complaints from individuals against the what we call government and other what we call sectors under the governments serviced by the both private and public what we call bodies, including corporations. So you can very well understand, my dear friends, there are certain, particularly I should mention one of the most important chapter, and that is chapter I think 16 of the Constitution of Sri Lanka, that takes into account, I mean in 19 what we call 78, some kind of a mechanism in the form of ombudsman was undertaken just to make the administration accountable, and where we find a designated authority in the form of what we call of parliamentary commissioner for the administration, and it was what we call appointed. This exercise was undertaken in 1978, but for the first time the real picture that emerged so far the appointment or creation of the institution of ombudsman in Sri Lanka was concerned, it was made possible only in the year of 1982. So that is another important development, because a wide range of subjects is under the jurisdiction of the parliamentary commissioner in Sri Lanka for administration, yet investigation cannot be initiated into certain subjects. For example, power or function of the legislator governing public security, appointment of public officers, etc., have been put out of the purview of the institution of ombudsman in Sri Lanka, because the constitution of the Democratic Socialist Republic of Sri Lanka, particularly of 1978, in its chapter which I have mentioned, under Article 1, if I am correct, under Article 156, this particular article, my dear friends, contemplates that the Parliament shall by law provided for the establishment of the office of the Parliamentary Commissioner for the Administration, and that is known as Ombudsman in my own terminology, but it is Parliamentary Commissioner for Administration Act that was passed. So administration in terms of Article 156 of the Constitution. Therefore, this particular piece of legislation passed under this particular provision of the Constitution of Sri Lanka defines the powers, duties, and functions, and provides, my dear friends, for matters connected with and incidental to the exercise of the powers and duties and functions of the institution of ombudsman. So you can very well understand, if you take into account the section 10 of the legislation, or this act provides for the Public Petitions Committee of Parliament to refer any petition presented by a member of Parliament which discloses an infringement of a fundamental right or transgressions of the fundamental human civil liberty or human freedoms or the civil liberties, or other what he call acts of injustice by a public officer or officer of a public corporation, local authority, or other like institutions to the ombudsman for the investigation and report. Therefore, Parliamentary Commissioner in Sri Lanka, my dear friends, has attained some kind of a what we call moral conviction. If this is a legislation that has permitted and that permits any person subject to a violation of a fundamental right or injustice at the hands of a public officer or authority, which has been what we call mentioned in the provisions of this legislation, to make a complaint directly to the ombudsman. An ombudsman has the discretion to investigate and report on such a complaint if he or she of the view that a breach of a fundamental right or injustice has occurred or has been what we call disclosed, or any kind of a pattern of violation is witnessed in the complaint itself. So it is very, very important, my dear friends. If you take into account another important what we call jurisdiction in South Asia, then this reminds me of a very important jurisdiction, and that is Bangladesh. Anybody from Bangladesh? No one is there? Well, in the context of Bangladesh, my dear friends, after the independence of Bangladesh, the framers of the constitution adopted in 1972 the concept of ombudsman or nyayapal, which is in Bangla language known as. It is basically the Article 77 of the Constitution of Bangladesh that provides that Parliament has been empowered by law to provide for the establishment of the institution of ombudsman. Ombudsman shall what he call exercise such powers and perform such what he call functions, and whatever the or some other functions which are likely to be assigned to it. Ombudsman has been further empowered, my dear friends, to prepare an annual report concerning the discharge of the functions, and the report shall also what he call incorporate, and it shall be laid before the Parliament as per the constitutional what he call mandate. But it has also passed, my dear friends, in the light of the mandate, in the light of what we call of the constitutional scheme, as per the mandate of Article 77, the government of Bangladesh has also passed an Ombudsman Act in the year 1980. If you take into account this piece of legislation, though it has not been fully implemented in Bangladesh, but at least some kind of idea has been what we call culled from this particular piece of legislation, and it is axiomatic if you go through the features of this particular piece of legislation, which is popularly known as the Ombudsman Act of 1980. So one of the most important and fundamental feature is that an institution of ombudsman shall be appointed by the president on the recommendations of the Parliament of Bangladesh. At the same time, Parliament shall recommend for appointment as ombudsman a person of non-legal and administrative what you call ability, probity, and conspicuous integrity, transparent integrity, visible integrity in public domain, and it shall come into force on such date, which may be appointed by the government in consultations with all the stakeholders, and it's what we call notification in the gazette of Bangladesh. This is the journal language which is always adopted by all the jurisdictions in South Asia. So ombudsman has been empowered, my dear friends, to hold office for a term of 3 years in Bangladesh from the date on which he enters upon his office, my dear friend, and or her office, and shall be eligible for reappointment for the one further what he call term. It means generally in cases as per this piece of legislation, as per the constitutional mandate, consecutively 2 terms may be granted, my dear friends, to an ombudsman, and it has also contemplated the removal what he call mechanism from this very office. So in the context of Bangladesh, my dear friends, as per this legislation, Ombudsman Act of 1980, ombudsman has been empowered to exercise certain specific powers. Power to punish any person who, without lawful excuse, obstructs him in the performance of his functions with simple imprisonment. A penal power has also been contemplated, which may extend to 3 months or with fine, and which may extend to what we call 1,000 taka in terms of currency or not. And at the same, both the inflictions may also be there. So all kinds of what you call we find a lot of similarities regarding investigating what we call administrative action against a ministry or the state officials or statutory bodies or other important functionaries, and it is similar to other important jurisdictions. In the context of India, the largest what we call nation state in the entire South Asian grouping, so it really requires, my dear friend, immensely require this idea of institution of ombudsman. Government of India, my dear friends, has designated several ombudsmen. Sometimes these ombudsmen were called chief vigilance officer for the redress of grievances and complaints from individuals in the banking sector, insurance sector, and other important sectors being serviced by both private and public what we call bodies, and other important what we call institutions, organizations, corporations, and so on and so forth. So CVC, Central Vigilance Commission, was set up on the recommendations of the Santhanam committee that has submitted its report during, and it was constituted, and it has submitted its report in the year 1962, between 1962 up to 1964. So in the context of India, the ombudsman is known as the Lokpal or Lokayukta, as I have already mentioned the day before what we call yesterday. An administrative reforms commission was set up on, I think, in the month of January 1966, under the chairpersonship of Shri Morarji Desai. It recommended a two-tier machinery, Lokpal at the center, and Lokpal was translated into English by this committee as a parliamentary commissioner at the federal level, at the union level, or at the central level. And it was what we call similar to the New Zealand model of parliamentary commissioner, if I am able to what you call draw some kind of comparisons. And at the state level, to redress the what you call people's grievances, Loka Yukta's office of the Loka Yukta was contemplated. However, the jurisdiction of the Lokpal did not extend to the judiciary, as I have already submitted. And it has become a bone of contention, and that is why I am again refreshing your memory that it must also be pondered over why judiciary has become some kind of a holy cow. Because we do not find any kind of a credible in-house mechanism to investigate any administrative, judicial, or executive injustice that has been internally or externally meted out by the judges. So there should be some kind of a mechanism to determine the culpability and responsibility or fixity of responsibility of the judges for their actions, which are ultra virus of the constitution. So some mechanism should be there. As we find in case of New Zealand, judiciary is included in the jurisdiction of the institution of Ombudsman, but this is not the case in other jurisdictions. In the context of India, my dear friends, Kerala state has an ombudsman for local self-government institutions like panchayats, municipalities, and corporations, which are popularly known as the local bodies. He or she can what you call inquire, investigate into allegations of actions, inactions, corruption, and maladministration. A retired judge of the High Court is appointed by the governor for a term of 3 years under the Kerala Panchayat Raj Act. In the state of Rajasthan, my dear friends, again in the context of India, that is another important provincial unit. Loka Yukta institutions was established in 1973 after the Rajasthan Loka Yukta and Up Loka Yukta Act 1973 was passed by the state legislature. In 2011, my dear friends, in India, anti-corruption movement led by social activist. He is a well-known figure. I am talking of Anna Hazare. Included its demands the creation of a stronger ombudsman agency with the jurisdiction over all state institutions through the enactment of a Jana Lokpal bill as an alternative to the Lokpal bill proposed by the government in 2010. Because this movement has created a new kind of a conducive atmosphere to have an institution like ombudsman. And the central government, my dear friends, introduced the first Lokpal bill and Lokpal and Loka Yukta's bill in 1968 for the first time, and further legislation was introduced in 2005, but has so far not been enacted. The state level Loka Yukta's institutions has developed gradually. I can give you an example of the state of Orissa in India, which is recently has been renomenclature as Odisha. And Odisha was the first state to present a bill on establishment of the Loka Yukta in 1970. But Maharashtra was the first to establish the institution in 1972. Other states, followed like, Bihar in 1974, Uttar Pradesh in 1977, Madhya Pradesh, Andhra Pradesh, Himachal Pradesh, Karnataka, Assam, Gujarat, Delhi, Punjab, and Chhattisgarh, Uttarakhand in 2002, West Bengal again in 2003, and Haryana in 2004. So therefore, the structure of the Loka Yukta is not uniform across all the states in India. Some states have Up Loka Yuktas under the Loka Yuktas, and in some states the Loka Yuktas does not have so moto powers of instituting an inquiry. So lot of in terms of mandate, but which I believe one nation, one what we call anti-corruption institution. We cannot determine, there should not be any kind of variations in terms of power. So it is very, very important, my dear friends, to understand Therefore, it becomes necessary to maintain the uniformity and transparency in terms of inquiry, in terms of investigation, in terms of powers, in terms of other important facets of what we call of our engagement in the anti-corruption and pro-transparency, what we call governance in our part of the world. Another jurisdiction, my dear friends, that comes to my mind is Nepal. And Miss Khadka, may I put a question to you? Would you like to educate me what kind of a, as per the constitution of Nepal, what kind of a transparency institution in terms of what we call, or you may call it the anti-corruption what we call institution, has been contemplated in under the constitution?
Good afternoon, sir.
Good afternoon, ma'am.
Under Part 21 of our Constitution, we have Commission for the Investigation of Abuse of Authority, and we also have a Act of 2048. Uh, uh, that
2048 or
48
2048, ma'am.
1992 AD.
Okay.
So under Article 238, we have the structure of how the commission. It is also a constitutional body. The commission is also a constitutional body.
Under part
Uh,
21 of the constitution.
and under Article 238, we have the structure of how
Yes.
the commission is formed and what are the qualification of our commissioners and the members of the
Hmm.
commission. And similarly, under Article 239, we have the function, duties, and powers of commission of the investigation of abuse of authority.
Hmm.
Uh, so we also have the act, and if we go into the website of the commission itself, the first thing we'll be seeing is online complaint.
Hmm.
So that is somehow,
Yeah, yeah. Thank you very much. It's a
I
very
think it's
long
ironic.
run mechanism under the
Yes, sir.
constitution. Each and every aspects, the terms and offices, year, appointment, reappointment, salary structure, removal mechanism, everything has been contemplated under these articles which you have mentioned. So the larger question, so I should not, because you have already spoken about all these I mean, institutional framework for the appointment. The beauty is that the Constitution of Nepal has contemplated this commission under, Part 21. So it is very, very important that the South Asian jurisdictions, and it is, solace for all of us that the South Asian constitutions are not what we call, I mean, are not without this particular institution. What is important for the South Asian what we call jurisdictions is how we are going to institutionalize the constitutional mandate. So what are the issues that becomes, cumulatively speaking, that becomes very, very important?
So
So
on the
yes, ma'am. Yeah, please continue.
sorry, sir, I thought you were asking me a question.
No, no, no. So issues, cumulatively speaking, if we try to address the issues in the context of SARC region, the first and foremost issue is the availability of the public services to the people without any discrimination. It means on the part of the administrative structures which have been established in the name of transparency, in the name of good governance, in the name of rule of law, ventilated via this particular institution, and that is the institution of ombudsman. We must what we call try to understand the idea of equality in access to public service delivery system. So this must be very conspicuous, very much visible when we are talking of something which has always been very discriminatory. So just to dispel discrimination, we require the idea of substantive, normative, procedural, and proportionate equality in terms of accessibility, in terms of affordability, in terms of enjoyment, whenever there is a question of the public service delivery system. And generally, my dear friends, it is found that the public services are available to the powerful, rich, and particularly those people who have access to the what we call portals of power, but not to the common people, the marginalized, the vulnerable sections of the society, the uneducated people, the economically deprived people, or the marginalized sections of the society. Therefore, the first issue is to ensure equality in access to public service delivery, which should be easily available as a fundamental right, as an entitlement of democratic citizenship, and it should be free from all kinds of biases, prejudices, or ill-conceived notions, and there should not be any kind of a determination exclusively so far access to the public delivery system is concerned. There should not be any kind of a determination on the basis of religion, color, ethnicity, race, gender, or caste, whatever may be the, or ethnic origins, or the membership of a particular social group, or political opinion, because the relationship is one of service provider and service receiver. Secondly, timelines, regularity, and the equality and quality of the public services delivery, should be ensured. And number three, my dear friends, public service delivery should be made what we call transparent and accountable. And the fourth point, fourth issue that comes to my mind is to make the delivery of the public services transparent, that which means any citizens can check for himself. Another important dimension to it, the value for money in public service delivery system must also be respected and ensured. And which public service are being provided by the government or the public agency, and which are ones are being what we call outsourced, and on what terms and conditions should be made known to the general masses. It is very, very important, because there should not be any kind of clandestine transactions and hidden what we call conditions. Another important dimensions of these cluster of issues is availability of the correction mechanism, ensuring people's right to what we call complain in case of what we call of complaints regarding any aspect of the public service and delivery, that should also be provided. And my dear friends, another important submissions I intend to make is that is a special emphasis on social justice, and dimensions of the public delivery system must also be what we call ensured. So these were my what we call submissions, but you have to supplement on the basis of, and you can further what we call add many important points on the basis of what we call of the literature that I have already shared. Meanwhile, if you have any questions, you are most welcome. And in the next what we call by tomorrow, I would share few important what we call submissions in the form of writings that I intend to email you. Number one. Number two is that on Saturday from 11 to 1 o'clock on Saturday, you are going to have your presentations, term paper presentations. For that, by tomorrow evening, you would receive an online link. So online presentation program has also been requested by me, and majority of the students have consented. So once again, I request you all, please make yourself available for the presentation program. So thank you very much for the day, and I'm immensely grateful to all of you that you have provided me this opportunity to engage you online. And I also intend to, my dear friends, to share the link of this video. Let me receive this video. I will also make it available to all of you, particularly for those people who could not attend today's online lecture. So thank you very much for being with me. Thanks a lot.
Excuse me, sir.
Yes.
Sir, should we have presentation from the team research paper or any
The
other
term
topic, sir?
paper that, listen, gentlemen, the term paper which you have written,
Yes, yes, sir.
yes, that is of 20 marks. You have submitted it. The writing part constitute 15 marks. 5 marks are given for presentation. So day after tomorrow, you have to make a presentation what you have written. Some questions would be there, at least 3 or 4 questions likely to be asked by your classmates. I may also what you call ask, but I would in put any questions, rather it is your classmates who are going to put questions. I am simply going to be a moderator, right? So we have to
Thank you so
assess
much.
your, we have to assess your performance, how you are going to deliver your intellectual, what we call, creativity.
Thank you, sir.
You're welcome. Because it should be very easy, because this is something you have already written, and you have
Yeah,
to
yeah,
make a
sir. Yeah, sir.
presentation. What are the important points? What exactly you want to say in your, what we call, term paper? What kind of an
Exactly, sir.
hypothesis you have identified? What kind of a intellectual disconnect you have identified, and you are going to fill that very intellectual gap. So all these things and many other important incidental issues would come up. So prepare yourself accordingly, and I wish you all the best, and we are meeting day after tomorrow. So thank you very
Thank you,
much
sir.
till then,
Thank you.
and please prepare yourself and for your examination, ensuing examination as well, and rest of the things I would submit on day after tomorrow when we are going to meet online. So thank you very much.
Thank you, sir.
You're welcome, ma'am. Thanks a lot. Thank you.